Hello, how you doing? My name is Matt Allen. I'm here with my ABA colleague, Richard Hong. Richard and I are members of the Securities Litigation Committee of the ABA section of litigation, and we're here to talk to you today about the Wells process in SEC investigations, and specifically to give you a securities litigator's perspective on the Wells process. Richard and I will give a brief introduction about our backgrounds, and we'll then cover 5 topics that are laid out in an article that Richard will publish with the ABA. It's a very good article about a step-by-step guide of what to do when your client receives a Wells notice, and that's broken up in 5 topics, and we're going to organize our discussion around those topics today. And I will give you a preview. We're really lucky to have Richard with us and on our committee because, well, he is now on the defense side. He spent a long time with the SEC as an enforcement lawyer. So we're really lucky to have his perspective and experience with us today. So without further ado, again, my name is Matt Allen. I am a securities litigator with the law firm of Miller, Canfield, Paddock and Stone. I'm based in Michigan, but I have worked with the SEC regional offices around the country. I think most of them, including their headquarters in Washington, D.C. I handle SEC enforcement actions, securities investigations, and private securities litigation and class action work. Richard, why don't you give the good folks out there a little background about you?
Thank you. Thank you, Matt, and thank you for inviting me to join you on this. So I'm Richard Hong. I was with the SEC for about more than 17 years as a senior litigator, senior trial lawyer in the New York and DC offices. Prior to that, I was an assistant United States attorney at the U.S. Attorney's Office in Miami for a number of years, and at Maine Justice a year before that. And I'm really happy to speak to you and hopefully help you a little bit about what to do when you get a Wells notice.
Great. Well, let's get into it. Why don't you describe, Richard, if you don't mind, just generally what is the Wells process?
So Wells process begins with something called a Wells notice. And Wells notice is a notice that the SEC staff, investigative staff, gives when their investigation matured sufficiently for them to make some preliminary determination about who they will recommend to charge to the commission. There is a process within the SEC where the staff makes a recommendation who should be a defendant or a relief defendant, and this process really begins with a Wells notice, which opens the door for a dialogue between the investigative staff and counsel, or for that matter, those people who don't have counsel, the potentially pro se folks, to have a discussion about what the SEC thinks that your client may have done wrong in connection with any violation of the federal securities laws. Now, the name Wells comes from a guy named John Wells, who had a committee a long time ago, an advisory committee, and they came up with this idea that, in order to make sure that there's some due process in this charging process, the SEC staff should issue a notice, usually a letter or a phone call or an email that says, hey, we'd like to have a conversation with you to advise you that your client may be charged by the SEC for a federal securities violation.
I mean, I had forgotten that's where the name come from, but it's a good reminder. And so I'll tell you something that I've tried to do on Wells calls when I receive them. Before you get the notice, I've made some attempts sometimes to head it off, and I'll try to convince the staff to before you send me a notice, send me as much of your file, your investigative file, as you can, and let me respond on behalf of my client before you issue it. So I don't know, perhaps it's a corporate client who doesn't want to have a disclosure triggered by receiving a Wells notice, or I represent somebody who's regulated by FINRA or somebody else, and they don't want to have a reportable Wells notice to receive. And And I'll raise various things as kind of arguments to allow me to do that. I'll I'll raise the fact that, hey, I'm here to help you out. You've got this 180-day deadline after you issue this Wells notice to bring an action under the Dodd-Frank Act, so we'll stop that clock from ticking. Um, Sometimes that the law is unique or the facts are unusual. That's something I'll say, hey, let's try to talk through these difficult things before we're on the clock. My position is that the settlement rule 408 kind of applies to those pre-Wells notice discussions, and so that's an opportunity to really talk settlement or perhaps work out a cooperation arrangement with your client before the SEC issues a notice and starts the formal process down the road to an enforcement action. I'm wondering, Richard, whether you've had annoying lawyers like me in your career make similar requests, and what's your view on that?
So, as a trial counsel, I did not get involved in the investigations early on it, but I got involved around the time when Wells decisions have to be made and when charging decisions have to be made. And, I work with the investigative staff to make those charging decisions. And my perspective is that actually frequent conversations, dialogue with the staff, like what you mentioned, Matt, is very helpful because you learn a lot about how quickly or slowly the investigation is going. What are some of the key things they're looking at? And you can prepare for that and you can make adjustments in your strategy in doing that. So I think that having those early discussions is very helpful and you may be able to head them off. But, once the staff is all set to issue a Wells notice, it's going to be hard for you to stop them from doing that. You could do a white paper, and I don't know if you've done white papers. Sometimes
Yeah.
the investigative staff will entertain a white paper, which does not start the clock that you mentioned. Sometimes they will allow you to make a presentation on it. I like, from a defense perspective, of making presentations once we have an understanding of where the investigation may be going to answer the questions and things like that. And I think that it's really a good technique, Matt, to kind of be cooperative and also uh, kind of guide them and push them and steer them in a direction you think they should be looking at instead of some other areas, to the extent that you can try to do that. I think the staff appreciates cooperative counsel who can be not only cooperative, but obviously you've got your own thoughts about what should happen on that. And if you work sort of together, it's more helpful, and chances are it will result in the way. I mean, it will probably produce a better result.
That's good advice, and that has been my experience. So we talked about topic one, what is the Wells process? Let's dive into the second topic, which is, all right, they sent out the Wells notice and scheduled a call to talk about it, the Wells call. Tell us a little bit, Richard, about your views on how defense counsel should handle that call and what to expect.
Okay, so generally you'll get an email from the investigative staff. If you were completely uninvolved with the investigation, you might be surprised. But if your client has been subpoenaed for documents or been asked to provide investigative testimony, the Wells call will be the next stage where they'll, as I mentioned earlier, indicate that investigation has sufficiently matured for people to think about who might be a defendant or a relief defendant. When you get an email and setting up the call, I think the first thing you have to understand is that you need to learn as much information as possible from the investigative staff. This is a listening mode call. You need to take extensive notes, have a colleague of yours sit in and take notes, and find out exactly what the SEC is going to say. Usually, the call will be fairly formulaic. They will tell you that it's a Wells call. They will tell you that they are made some preliminary determination and that your client may be a defendant that they may recommend to the commission. They will go over the charges, proposed charges, They may, depending on who you talk to and what kind of relationship you have with the staff, provide you more factual detail. But a lot of times you're not going to get more than a high level summary on that. And take all of this down and find out exactly whatever they want to tell you. And then what you should do is, and do this in a very professional, non-argumentative way, but to say, hey, we need some more information. Can you tell us a little bit more of the factual summary? What is the basis for this? And prod as much as you can and try to get them more information on that. The staff will, depending on the staff, depending on the relationship, depending on what kind of deadlines the staff is working on, they may be more receptive or less receptive. The next thing that the staff will tell you is that you got 2 weeks to submit a well submission, and they'll send this via email, the summary for it. But they generally give you 2 weeks, and you got up to 40 pages in your well submission, or you could do a video submission if you like. And they will go over those things, and they will go over the deadlines when they would like to have a well submission. My recommendation is, whether you make this request on the first call or on a later call, is ask for an extension. Unless you have a lot of folks that are working with you and you're totally familiar with the investigation, which is generally not the case. The staff has been looking at this for months or years. You probably have been looking at for weeks, days or weeks. So you will need more time to do it. Ask for another 2 weeks at a minimum, or whatever the time you think you need to do. Sometimes the extension request is better done on a second call, just to build a relationship. So, but one of the things you want to do is, on this call, ask for more time, whatever the time they want to give you, and then basically ask whether or not they would provide some discovery, some information, so you could actually use it to write your submission. Oftentimes, people ask for investigative file. They're not going to give you an investigative file, but they're going to give you a portion of things. If your client testified, you might already have ordered the transcript, but you should ask for that. You should ask for any relevant documents that the SEC may want to share, any investigative exhibits and so forth on it. You might also ask whether or not there's some other relevant testimony that they might want to share, or at least portions of it to do that. Your strategy ought to be cooperative, professional, and as you know, I mean, try to request as much information as you can so you can provide an effective well submission. You should be
Yeah.
mentioning to the staff that, look, I need more information to give you a well submission that is going to be helpful to you. So if you don't help me, the output's not going to be very helpful to you on that. So if you are serious about engaging in a discussion, and from my experience, the staff is, you should give us the information we need to work on this. And that's the approach, I think, in a nice way to
Yeah.
do it with it.
Well, I think that's exactly right. There are two things I add. The first is just what you said. Look, give me information. This needs to be a good work product. I'm going to get this stuff anyway if we litigate. So let's just get in front of it now to help me give you a good product so this process is fulsome. The second thing I always ask about, of course, is look, is there a DOJ file open on this? Sometimes that there's either a referral or a potential referral. You'll get grand jury, activity from people involved in the transaction or the company. Sometimes it's pretty obvious that this is just a civil securities thing, but sometimes it's close and you don't know. And I always ask the question, and the results are not very good about what they'll tell me about involvement of the Department of Justice in any criminal issue. So, I'd be interested in your perspective on that. I'm sure maybe you haven't as an enforcement lawyer. Maybe that's more of an initial staff question, but certainly when you get involved with the enforcement folks, if you still have those questions, it's one that I ask. But I'm interested in your perspective on that.
So, most of my experience is based on my New York and DC experience, but I will say that majority of the cases that I worked on as an SEC lawyer had some criminal interest. Okay, they inquired about it, or we referred and said, "Are you interested in this case?" There's usually some sort of conversation that occurs, Now, where that conversation goes is a different story. Some DOJ components or U.S. attorneys may be very interested, or they may not be interested. But there's usually a contact on that. And once there is a contact, then the SEC can work in a parallel fashion or sometimes jointly with the U.S. Attorney's Office and on the matter. When I got those questions asked, it's an uncomfortable question to ask. It really is because, obviously I know some information or I have some inkling of information, but it's not my right to say about what DOJ may or may not be doing. So, there's an enforcement manual that specifically says what the staff should be saying, and they're given guidance on it, and they basically walk the line, whether or not there's an investigation or not. And I find most of the stuff that staff tells me on this, because I did it myself, uninformative. All right. So, so what I do is, Matt, is as a defense side, is that I'm going to try to find out, from other sources, whether there is an investigation on it. Not if there is a real investigation going on with grand jury subpoenas being issued and people being called, we'll hear about it. We'll know about it. Our network will allow some information to doing that. Now, if it's a covert operation, no one knows about it. And the SEC may not even know the full extent of a covert operation on that. So they may very well be telling the truth. One of the things that I think, ought to be asked, and we do that here, is, in order to have DOJ involvement, the SEC and DOJ have to exchange something called an access request. It's a letter sent by DOJ that says, we'd like to get your documents and things of that nature from you and the SEC. And I'd like to ask those questions about whether or not any access requests are given or anything of that sort, because that will indicate to me the level of interest on it. Usually, if the U.S. Department of Justice sends an access request, there's more interest in this, and I would be more concerned. If there was just a phone call or two being exchanged, I'm not sure I'm that concerned.
Yeah. No, good advice. And again, it's not just the DOJ, of course. It could be if you've got an accountant or an auditing firm, it's the Public Company Accounting Oversight Board who may have parallel proceedings, FINRA, of course, state agencies. So I think you just got to kind of understand, which agency may touch this topic of the Wells notice, and then kind of be aware of it. Well, let's talk about topic 3. We've received the notice, we've had the call with the staff, we've gotten as much information as we can, and now the time has come to determine whether we want to submit a well submission. So I guess my first question is just real generally, I'm thinking the audience here knows what it is, but if not, just briefly describe what a well submission is and some of the reasons to maybe make one.
Sure. Well submission is essentially like a long or brief or memorandum made to the commission. It is given to the staff, but it is also going to be distributed to the commissioners if there is any recommendation to it. So the audience is not just to the investigative staff, but it's also to the commissioners who make the decision. And I mentioned that because that's when you are framing this thing, you should think about your audience, who's going to be. It's not just the folks that you talk on the phone on the Wells call. It's going to be a broader segment, including senior leadership at the SEC Enforcement Division. So keeping that in mind, my advice to clients is that in most cases, assuming that the client has the financial resources to do it, because it will be some work, obviously, by the attorneys, is that the answer is yes. You should submit one in most cases. The stage is the best time to persuade the SEC to not bring charges or bring lesser charges. And you should use this opportunity, the 40 pages, to really explain and contextualize what was going on here, especially in a complicated regulatory cases like a reg show case, which is, I think no one understands what a reg show, what reg show is really. This is a golden opportunity, a unique opportunity to tell your side of the story, meaning your client's side of the story. And the key thing I would think about is use this opportunity to contextualize And an individual, if you're representing individual, you need to personalize them in this submission. You need to make your client come to life. You know, quite simply, the SEC decision makers, the senior decision makers who will review this along with the investigative staff, don't know your client. They only know what the investigative staff has told them. And that could be a lot or that could be limited. The decision makers may view your client as essentially a cardboard figure. You know, you need to make him or her, or even if it's a corporate entity, come to life and show that, you know, it's not a fraudulent operation, or it's not just violating the SEC rules or regulations, but it is actually an ongoing productive entity that is doing business and is trying its best to comply with the federal securities laws. You know, well submissions don't work all the time. In other words, that doesn't result in not bringing charges or lesser charges. But in my rough estimation, based on reviewing scores of well submissions and at the SEC over, close to 18 years or so, I would say roughly it works about 20% of the times, maybe 25% of the times. And so that's not a negligible percentage,
No, no.
So you want to take a shot at this,
Yeah.
And I would tell you this: not saying anything can sometimes be hurtful because the staff kind of assumes the worst if you're not saying something on this.
Yeah.
And there may be reasons why you don't want to submit stuff, and which you'll go over a little bit, Matt. But I mean, you also need to think about optically what it looks like.
Yeah.
And and lastly, even if you're not going to litigate the case, you want to present your well submission in such a manner that it positions you or your client best for a resolution later on. Again, contextualize the situations and understand why these violations may have occurred or may not have occurred, but kind of, again, gives you a background for a different resolution than what the SEC is looking for. So those are some of my thoughts.
Well, let me highlight two of them that I think are really good and worth emphasizing. Know your audience, right? The staff oftentimes refers to my client as the 5 SEC commissioners. So that's a good point. Know where this Wells is going. And the second is a great point. Humanize your client. Unless this is a total Ponzi scheme and house of cards, there's oftentimes legitimate, productive things that your client is doing in the business world. And so, the first slide I put on my presentations, whether it's to a DOJ lawyer or the SEC, is let me introduce you to Bill Jones and talk a little bit about this guy and what he's done. And that's the start, because you're right. They see a cardboard cutout, and they probably got an org chart of where your guy fits. And so I think that's great advice. And so I'll just tick off some reasons why folks may not want to file a well submission. And I've made these decisions not to file them in a few cases. And it's mainly because there are issues beyond the securities issue in play. And most of the time it's criminal. If there's a serious enough prospect of a criminal proceeding, what you put in a well submission could waive your Fifth Amendment right to remain silent, which you have in the criminal case. You have it in the civil case, but you can have an adverse inference, and that's for another podcast. It'll create admissions for you in those cases if you make them. Sometimes your client is such a top target and so high up that you're pretty certain that there are going to be no immediate opportunities to meaningfully settle. And so the only thing a Wells submission does is kind of give away your defense and trial theories and help the SEC shore up its weaknesses. Other things to consider is the fact that your submission is going to be discoverable by private litigants and other regulators. Oftentimes in these cases, when they're big enough, there's a criminal component, there's a regulatory component, and then there's the civil class action component. So those are reasons to do it. And other things to consider is understanding who your client is, right? If you've got a corporate client, you don't have a Fifth Amendment right to remain silent. And so, that should enter into your calculus. The Department of Justice has just issued new cooperation guidelines that for the first time give some really formal standards for when they will give your corporate client a declination letter. We're not going to prosecute you. And so that's pretty exciting for corporate clients and a really good incentive to, if you're going to submit a well submission, really understand the prospect of how helpful it could be. And then, of course, the other thing corporate clients need to consider is, if they've done any sort of internal investigation, how do they want to handle waiving the privilege to produce and disclose that information? Because, of course, when you do that, there's no selective waiver in many circuits, and the Federal Rule of Evidence 502 is helpful there too. But I think you need to plan on if you're going to disclose investigation materials that you've waived that privilege. There are other issues if you've got an audit committee, a director or an officer, or a regulated person. I'm not going to go through all of that. It will belabor the point, but I think the general point is know who your client is when you're getting ready to submit a well submission.
I just want to sort of highlight a couple of points that Matt mentioned. I think Matt, that's a really great advice you provided. For one thing, first, let me say is that the SEC does not view well submission as a settlement document. They do not view it as something that is covered under Rule 408. So when you submit it and you think it's confidential and it's governed by Rule 408, it's not. The SEC won't do it. They will use it in litigation to do that. So understand that is the position, and you can drop as many footnotes as possible in these well submissions. I've seen many of them. Many great law firms do that and say it's not subject to 408. And I can tell you the staff doesn't really pay attention to that footnote. Okay. So you should understand that. The second thing on the criminal cases, if there is some cognizable belief there is a criminal case, I advise my client that it is not the best idea to submit a well submission. And I'll tell you why, because the SEC has basically sharing information, and you get that from the SEC forms that they give you, where it says, look, we're going to share information with criminal authorities and law enforcement authorities. So you should assume that if there is a criminal investigation, the SEC is going to provide a copy of the wells to the criminal authorities. And you got to understand what impact it is. And you may want to shape the well submission a little bit differently, knowing that your audience is not just all the folks at the SEC, but at the Department of Justice. The second point. And the last point is, I would say is, there are some cases where the evidence is really pretty obvious. There's an egregious fraud, the Madoffs of the world, shall we say. I don't think any well submission is going to help Madoff on that. So, in a situation like that, I would recommend that it's probably not worthwhile to submit it. You would say that, thank you for the opportunity to submit a wells. We decline it and then go forward with that because it's probably not worth the effort to doing that. Now, most people still do it. I think that those things are going to be less than productive use of time and money.
Yeah, great point about the settlement too. I never put as a practice so I don't conclude with the settlement offer. I ask for a meeting after, and that's when I do it either orally in that meeting or sometimes separately. But great points. Okay, topic 4. We're gonna do this. We're gonna submit a well submission. What does it look like, Richard? Why don't you tell us generally what it should look like, and I'll give you a couple of things about what I don't think should be in there.
Sure. So it should look like, and I'm just going to break it down in granular level. It should have first of all, let me tell you how you prepare to do it. Okay. You get as expeditious as possible because you're probably going to have anywhere from 2 weeks to 4 weeks, a very limited time. Maybe you get a little more time if the staff is nice, but you're going to have very limited time. Get as much information, marshal as much information from your client, preferably documents that you can use and cite and quote. Get as much information from the SEC, the preliminary call and any other follow-up calls that you may have with the SEC regarding the well submission. The SEC is usually amenable to additional calls on the well submission. So take that into account and take advantage of that. Get as much information as possible from the SEC, including any pre-lawsuit discovery that Matt mentioned. And then any third party who are involved in this investigation, whether if you're representing an individual, the company's counsel that is involved may have some information and maybe is willing to share some information, whether it's documents or testimony or some other things on that. So get as much information as possible, as quickly as possible, and figure out what the objective of the submission is. You know, are we going all in and saying that this should not be brought at all? Are we going to make our arguments we would if we were at trial, basically? Or are we going to hold back a little bit for whatever the reasons? And I think Matt discussed a number of good reasons for that. And then the other consideration is this really a precursor to a settlement negotiation? What's the ultimate goal? That should drive how this document is done. And depending on what your goal is, you know, you should prepare the document somewhat differently on that. What should it look like? Let me just finish a couple more points, Matt. Yeah. I would say, what does it look like? You know, I think there are three things at high level that you should consider. You got to tell your story in your submission. You got to personalize, humanize, contextualize what happened in your client's voice. Okay. If your client is not a high level executive, but someone who is running a small business who got caught up in this securities stuff, you should try to make it in his or her voice. Don't make it sound like JP Morgan. Okay. I mean, I think second thing is you should explain why no enforcement action is necessary. There's no wrongdoing, or the wrongdoing is small, limited, or old. It's not material, material under the federal securities laws, or it's not worth an enforcement action because it really serves no interest to the investing public. Remember, one of the things that the SEC is trying to do is protect investors, right? And make sure that the capital markets are safe. So is it really serving those interests to doing that? You know, some arcane rule somewhere, right, in Reg Show, does it really do anything? And besides having compliance department be worried about stuff, you know, is it really that important in the scheme of things? It's important as a securities law, but is it really, realistically, practically speaking, that important? You know, is that, or is it some other interests that there's some other agencies already handling? You mentioned PCAOB. PCAOB is handling the audit issue. You don't need to go there, SEC. They're already all in on this. And then the last thing I would emphasize is, look, you gotta go to the litigation risk. Okay, you gotta tell why actually litigating this case, once the SEC brought it, will be no fun for the SEC. Quite simply, because of the litigation risk. You need to spend a good amount of time on litigation risk in your submission. What could go wrong at trial? All right. What could go wrong during discovery? What could go wrong in motion practice? And I'm not, I don't think you should spend 20 pages on this, but you should spend enough pages to understand that there's some significant or substantial risks when litigating it. And because that's how I looked at it when I was there. Was there significant litigation risk in this? And how would I address it as the SEC litigator? And if you put yourself in the shoes of where I was and say, this is going to be a real lift in litigation, I think that resonates at least with some people who are going to be reviewing this.
Yeah, all great points. Well, let me tick off reasons, let me tick off some things that you don't want to include in your well submission, what it shouldn't look like. It shouldn't be an ad hominem attack on the staff or the SEC, high level of policy attacks, not the business of a well submission. I don't make long legal arguments and non-controversial points. The staff is smart, the lawyers are smart, they all know the law, and so if I do any sort of in-depth legal analysis, it's a reg or a law that's kind of new and it's a little up in the air about how folks are interpreting it. This isn't a jury trial. These folks aren't going to be persuaded by a lot of theatrics, so keep it, as you indicated, professional and hit on the issues. I usually don't spend a lot of time on minor issues. If we're dead to rights on some books and records thing, I may not spend a lot of time on that. I'll focus on the bigger fraud things. Don't overstate the facts of the law. Again, these folks are smart. If you start taking liberties with the record or with the law, they're going to know they're not going to trust you. So that trust, I think, is really important. We've already talked about not including, in my view, don't include any sort of cooperation offers or settlement offers in your well submission.
So I wanted to talk about a couple other things. Is presenting exculpatory evidence in wills.
Yes, great.
Do you want to take that, or shall I address
No,
it?
no, no, no. It's a great point.
So it's effective, quite simply. If there's exculpatory evidence or that tend to be exculpatory, okay? And a lot of the folks who done criminal work would be considering this as sort of Brady evidence, Brady materials, or things like that. When the SEC doesn't have Brady obligations with respect to filing its federal court actions, because the federal rules don't require it on it. But when they are proceeding with an administrative proceeding, they have Brady obligations. So at this point, when you're talking about well submissions, you should be asking about Brady materials to the staff and whether or not it can be submitted. And if you have it through the SEC or independently, you should be presenting that, because presenting that kind of evidence is very effective in saying, again, going to the litigation risk on that, presenting the litigation. So if you have that, you should present the Brady or the exculpatory evidence. The second thing I would say is that if your case is super complicated, very, very technical and very regulatory, again, I go back to Reg Show, you should probably have an expert present some type of report. Now, it's way too early in the game to disclose experts and all that stuff. And some folks may say that's not the wisest thing to do. But you know what? If the expert is very good, right, is recognized, and there aren't that many experts in that area of his or her stature, and this expert agrees with your position, why not? I
Absolutely.
think could be very effective to doing that. Certainly, I've been on the other side where I saw some expert reports and I thought, this is pretty good. Again, this poses litigation risk. I think when I present litigation risk, Matt, I'm not trying to say I'm going to win at trial. What I'm trying to convey to the staff is that you got some issues too.
Right.
You got litigation issues, and you may not win. And that's what what folks who are doing well submissions should be doing.
Absolutely. And two very good points about exculpatory evidence and consideration of expert reports. So we're on to topic 5. It's the last one. We've submitted our well submission. We're going in for a meeting. Two big topics. Who am I meeting with and who should I ask to meet with? And second, how do I conduct that meeting? There are certain things I don't usually work around the staff. If I think that I want to have enforcement division folks in there, leadership, and if the case is big enough, SEC commissioners, but I've never had them in the meeting before. But I always work with the staff, ask questions, and if there's someone I think I want to be there, it's just a cordial discussion with the staff to ask about it. Sometimes it's, I hear you, Matt. We'll start with the staff on this one, but let's see where that meeting goes, and after that, we can include, X, Y, or Z in the next meeting. That's my experience on that. And as far as what the meeting looks like, we've covered some of it. Humanize your client, talk about some of the productive things they've done in their business and personal lives. Be prepared, man, be prepared. Know the facts and the record. And if there's something you don't know, offer to get it to them right after the meeting, if not in the meeting, by sending an email to one of the smarter, younger people that I usually work with on these things. Be organized, I have kind of an outline, talking points, and if there's stuff I really want to hit, it's an organized presentation. I usually don't want to take up more than an hour unless we've got a good dialogue, colloquy going. My goal is to be in and out in an hour or less. Answer the questions from the staff. It's like oral argument with the judge. I mean, don't sidestep questions. If they got questions, answer them, even if they're hard. and be honest. Sometimes it's like, look, that's not a great piece of evidence for us. But let me talk to you about why I think that's not going to be as effective for you as you think it will at trial. Again, just like it's not an opening, it's not a closing. This isn't a closing argument. Again, it's professional. These folks in that room are going to be smart, they're going to be prepared, and so I think you should be equally prepared to have a reasonable, kind of knowledgeable discussion about your submission and why you think the SEC should do whatever it is you're asking them to do in the meeting.
Yeah,
Interested in your views.
those are great points. Let me give you what I saw when I had these meetings, my perspective as an SEC lawyer. First of all, you didn't get commissioners to come in because they can't join these meetings. They can't. So that's, if you're asking commissioners to join, 10 out of 10 times you're not going to have them to do that. There are rules on this, on when the commissioners can actually participate in this thing, and it's not through the Wells process on that. They will get your submission when the staff makes the recommendation, but not before that. So generally, they give you an hour, as Matt said, and you can ask a meeting with the most senior leadership, depending on the nature of the case, the complexity of the case, and the dollar amount, and all the other, how many investor victims that the SEC may think there are. All these guys will make you kind of go up to whether or not you meet the director for this or another senior officer. So generally, the SEC policy is provide a meeting when if you request it. My view, personally, looking at the meetings and how sometimes the meetings changes the complexion of things, 10 out of 10 times you should ask for a meeting and meet at least with a senior officer, associate director level, associate regional director level, to talk about it. The supervisor, the senior supervisor, supervising the investigation on that. And then, depending on what kind of case it is, you may ask after that for the director or deputy director to sit in as well, the folks in DC to doing that. As Matt said, this has to be professional. I mean, yelling and screaming never works. And to the extent that anybody thought that yelling and screaming and making a fiery closing argument work and they got the result, I hate to tell you this, but I will tell you this. It wasn't your oral advocacy that did the job, okay? There were other issues in the case that were lurking about it on that. So be professional. Everybody's trying to do their job, whether you like the SEC or not. They're all trying to do their professional job, and they're trying to make the right decision here, quite candidly. So we should view them with respect, and we should be dealing with this in a professional level. And it should be a conversation. I mean, it may be we may disagree on the points, but try to have a dialogue. Remember, you're setting it up for a potential settlement if you want to settle this case. So you come in like a raving mad dog is not that helpful, that process, right? So think in those terms about how, and one point that you made, which I think is really, really important, is that being reasonable, okay? I mean, you really need to go in and say, look, if there are points that the SEC has that it really can't be disputed. I mean, your client did X, Y, and Z. I mean, own up to it, fess up to it. So yeah, I understand your point. I get that point. But as Matt said, let me tell you why it's not material. Let me tell you why that is not as important as the other issue on this. And don't argue every point, because there are points that clearly the SEC will have that can't be disputed on it. And arguing over those things makes you very unreasonable and not credible in front of the leadership there, when you want to be credible in front of the leadership to do that. The last point I'll tell you, one of the most scary things I had was defense counsel knowing the facts better than the staff. Oh my gosh. When I see, and I usually, as a litigator, as trial counsel, I'm not as close to the facts as the investigative staff. But when I see, and this happens not frequently, but it happens from time to time, where the defense knows certain facts better than the staff and raises the points that tend to suggest that the investigation missed things, overlooked things. That is the most effective presentation. And we all go back after the meeting and say, okay, what about that point? Tell me what it is. And how come it wasn't discussed before, because usually the staff has pre-meetings and the leadership is familiar with the major issues and so forth in part of the preparation. So if something comes out that, that is new and different, that is very effective in saying, maybe we missed something. Maybe we got to look at this more and we got to pause on that. And those are the results. Those are the things that you want to be at the end of the submission. One thing I would say, oftentimes, in the presentation, if there's an interest in settlement, counsel will make suggestions about settlement. I think the better practice is to have a separate meeting afterwards about that point. You might want to just highlight that there's an interest in talking about it some more. But I think you should try to separate them with that, because in my view, submission is not to talk about dollars and cents and about violations or not. It is to show that there are some issues with the SEC's case.
Well, Richard, I think that's a perfect place to leave it. It was a pleasure doing this with you, and I hope that our dialogue here is helpful to the folks out there. So thanks so much for your time.
Thank you, Matt. It was a pleasure, and I hope folks enjoy this program. Thank you.
Take care.